Good morning, sir. You're Corey Flemings.
Yes, ma'am.
And Mr. Flemings has two cases, 24 DCCR 2144 and 2145, set for trial to begin with jury selection next Monday. What is the announcement?
Judge, we're ready, subject to a ruling on my motion to quash the enhancement portion of the indictment.
State's ready to proceed.
I would ask which case Mr. Coleman intends to try first.
We intend to try the assault on the peace officer, Judge, and put on punishment evidence pursuant to our notice of extraneous offense of the injury to the disabled person.
And so the enhancement portion wouldn't change anything other than potential punishment.
Yes, ma'am. It would require you to declare a penal code statute unconstitutional.
Oh. That would be novel for me.
Yes, I figured it was. I have a case pending in the 9th right now with the same issue.
So hold on a second. Let me look at the indictment. Is the enhancement alleged? Yeah. So it's alleged in the indictment, and so I would need to make that ruling prior to jury selection.
Yes,
so
ma'am.
that well, we don't talk about punishment range in the jury selection. We'll talk about it. I'll get the case numbered, and then if it's numbered 1, we'll handle it either prior to or just after jury selection, because it won't change anything that you say in voir dire.
I think that if the punishment range is 25 to 99 and he is convicted and goes to the jury for punishment, I do believe I get to voir dire on the potential range of punishment.
And if he gets to voir dire on it, certainly the state would ask for reciprocity on that.
I don't have a problem with that.
Well, here's how I handled any enhancements on punishment, and how I would intend to handle it is I do not go into specifics or allow you guys to go into specifics. I will, in my part of talking to the jury, explain that there are different circumstances that could lead to higher punishments or lower punishments depending on the evidence that's presented. But getting into specific, especially priors, if I'm going to make some ruling potentially that they're not admissible or that we're not going to get to until punishment, we're not going to get into that on guilt innocence. We're not going to get into it on voir dire very specifically, other than if there's something, because if you allude to it too much, I think you're putting yourself and your defendant in a position where you're telling a jury up front that he has potential criminal history that could go into their decision making in guilt innocence. So
Yes, ma'am.
we're not going into that. I'll say what I say, but as far as spending a lot of time on it, that's not going to be an issue during voir dire. I'm not going to allow it to be one, but I will make the ruling that day so that we know before we get started. If it's going to change anything about the status of trial, and if I deny it, y'all want to renegotiate, or if I grant it, then let me know that. If you think it'll change anything, then I can make that, we can get something done either later today or tomorrow. I'll take a look at it so that you know ahead of time, because I want to know that, if I deny the motion to quash, which it sounds like I likely am not going to find our penal code section unconstitutional. If that changes Mr. Fleming's position, y'all talk about that today, because I want to know that if there's going to be some type of negotiation and a plea, I want that done today.
Yes, ma'am.
Okay?
Of course, information, regardless of how the court rules, the state's prepared and willing to proceed to trial.
Yeah, no, it's gonna be numbered, and we're running low on, the number 1 just pled this morning, and so it's likely this could go. So I want talk to Mr. Flemings. I've looked at the motion to quash. If y'all want to talk about it real quick, I can let you make your argument at this point.
I think we already talked about it.
I think we did. And so, I can go ahead at this point and deny that motion to quash that you filed. And so that way, we've talked about it. I've read the state's brief. We read what you filed, which had your information in it. And so that being done, y'all, if y'all want to talk, if that changes anything.
Yes, ma'am.
Okay, so do you want me to hold it while y'all visit? or-
I've got a meeting I've got to go to. I will visit with him, and then if it's gonna be a plea, I will advise the court. and
No,
we
it's
can-
gonna plea today.
Yes,
Y'all
ma'am.
need to talk now
Yes,
or
ma'am.
before docket's over.
Yes, ma'am.
Okay, I'll hold it.
All right.
I don't see a, order on his motion. All right, so are you David Chapman?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
Here we are.
Mr., let me get this pulled up. We're going on more than one count. Mr. Chapman, in cause number 23, DCCR 2228, you're charged with the state jail felony offense of unauthorized use of a vehicle from November 17th of 2023. That indictment alleges that you were previously convicted of the third-degree felony of harassment by a person in a correctional facility, June 10th of 2016. And then after that was final, you were convicted of the third-degree felony offense of assault on a public servant, October 28th of 2019, in two different cases on that day. Which, and how do you plead to that charge? How do you plead to the unauthorized use of a motor vehicle? And are those prior convictions true? Did you enter your plea of guilty and true to those prior convictions freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Chapman's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a motor vehicle. Find those prior convictions true. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You'll receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.